Yes, so we're moving on to the last part of your submissions, I think.
Indeed, my lord. Before I do, two small matters of housekeeping.
Yes.
Firstly, possible questions. I've had a discussion with my learned friend. We both think, in the light of my lord's indication earlier, we may be better off just to have another look at the document we had been working on. My lord, we will do so overnight and try and have something ready for tomorrow morning rather than rush to get it up today and interrupt.
Right, we would need time to look at it before. I mean, the appeal, the time estimate for the appeal, I think, is a day and a half. And we would need to see what's proposed and have a discussion amongst ourselves and then come back to you before finally rising. So therefore, if it's not going to be tonight, then as soon as possible in the morning.
My lord, indeed. Our understanding is the estimate is 2 days, I think.
Right, I was just looking at Lord Justice Popperwell's order.
And the parties then requested
Okay, fine. But actually, at the moment, we're on track, subject to the point about the questions and so on, we're on track for a day and a half, because we've reached your last section.
Well, Mr. Caruth to follow on apportionment, my lord, we're on track for 2.
Oh, okay, I'd forgotten about the apportionment point. Yes, all right. That doesn't detract from the need to have it sooner rather than later.
And my lord, the second point, if it assists in response to my Lord Justice Nugee's point, we do have a plot showing what I meant by that if it's 3 degrees and 3 degrees, it comes to a 6-degree reciprocal. Now, I don't know if I've managed to make that good orally now, or whether the panel would be assisted to see that.
I think we would be assisted by...
I think I do understand the point, but I think a diagram always helps.
Yeah. I've given copies to my learned friend and his team, and there are 5 copies there.
Very much.
Thank you. And so this shows vessel A on the left on a heading of 090 degrees, and the blue dotted lines are the limits of the visibility of her sidelines. And vessel B, over to the right, she's on a heading of 264, but that mathematically follows from the fact that we've aligned her side lights, the limit of the visibility of her starboard light, with the limit of the visibility of A's port light. So these are vessels right at the limit of what we would say is ahead or nearly ahead, right at the limit of the visibility of both side lights, and that puts them mathematically onto a reciprocal which is 6 degrees apart. And that was the point I was trying to make earlier. It's much neater done with a diagram. And that underlines the point I made to my Lord Justice Foxton about one really has to treat our submission as a package. What we are looking at is the key visual identifier is the side lights, and everything else then follows. And that leads me on to the definitional issue. The starting point is that the rules consistently use the word deemed in the sense of defining. We give an example in our skeleton argument of Rule 3K, which is a bundle, Authorities Bundle tab 13, page 219. And Rule 3K, vessels shall be deemed to be in sight of each other only of one another only when one vessel can be observed visually from the other. That is clearly not a deeming provision, notwithstanding the word deemed. My learned friend makes the point that that does include the word only, whereas Rule 14b doesn't, and I accept that. But one can look at other deeming provisions in the rules. 7.
Hang on a minute. This is in the definition section of what's its actual reference?
This is general definition.
Yeah, so it's Rule 3. Is it Part A? Rule 3, general definitions, and this is the
dealing with
little
when vessels.
K.
And my lord, but equally, 7D1 dealing with the risk of collision, such risks will be deemed to exist if the compass bearing of an approaching vessel does not appreciably change.
So that's page
220, my lord.
220.
But that is not a complete definition of what risk of collision is, because little 2 says you can have a risk outside that.
Indeed.
And it says shall be among those.
Indeed. But it is not a deeming provision in the sense of deeming something contrary to the fact. But my lord, then 12b, this is dealing with sailing vessels. For the purposes of this rule, the windward side shall be deemed to be the side opposite to that on which the mainsail is carried. And then 13b, the overtaking rule, which the Supreme Court was looking at. A vessel shall be deemed to be overtaken when coming up with the other vessel from a direction of more than 22.5 degrees abaft her beam. None of those provisions include the word only, and the latter in particular is defining when a vessel is overtaking, and we saw that from the Supreme Court decision in Eversmart this morning. And again, notably, we don't need to go back to it, but at paragraph 56, the Supreme Court specifically saying that it is 13b that triggers the overtaking rule. Similarly, in relation to 7d1, again, we don't need to turn it up, but paragraph 57 in the Eversmart, the Supreme Court said that although it was couched in terms of a deeming provision, it is clearly not a deeming contrary to the facts. So, my lords, we do submit and rely upon the fact that one would expect there to be a defining provision within a rule such as 14, or indeed within a rule such as 13, which, to go back to the wording of Sir Nigel Tier in the Apollo, sets the limit of what is nearly reciprocal, and to adopt the wording of the Supreme Court in the Eversmart, provides a precise specification which triggers the application of the rule. That was paragraph 56. But I did say I would need to come back to a couple more paragraphs when I dealt with the defining issue in the Eversmart. Can I ask my lords to have tab 8 of the authorities bundle, page 76. And paragraph 41 we've already looked at, but providing that stressing the need for the rules to provide a clear and readily ascertainable navigational rules capable of application by all mariners. We've looked at the precise specification wording and the wording of the fact that the lighting rules work in tandem with those triggering specifications already. But looking on to paragraph 68, if we can, where the Supreme Court refers to the overtaking and the head-on rules, and just below letter G says they apply, that's those rules, whenever the vessels are not head-on and one is not overtaking the other. Both of those exceptions, and that's I mentioned I was going to come back to that, are clearly defined. Precisely defined. So that's the quote I had in mind when I referred to the Supreme Court referring to them as exceptions this morning. And again at paragraph 87, the Supreme Court, paragraph 83.2, page 87, the Supreme Court pointing out that the steering rules, so that includes Rule 14, are generally very clear and precise about the requirements for their engagement. And none of those observations by the Supreme Court would be correct if Rule 14b was not a definitional provision. And so we do submit.
That's slightly overdoes it, doesn't it? So they wouldn't be correct. It may be that 99% of cases fall within 14b one way or another. But anyway, I understand what you're saying.
I should rephrase and say this. In our submission, all of those observations of the Supreme Court proceed on the basis that 14b is a definitional phrase
In the same
defining
way
it.
as 13b.
In the same, precisely, Mike, in the same way.
It's that equivalence that is at the heart of the reasoning, as I understand it, of Lord Briggs and Lord Hamlin, that 13b and 14B are effectively doing the same job within their rules.
They are doing the same job. They are defining the exceptions when crossing, when the vessels at risk of collision are not crossing. And as Captain Hurst put it in the first of his two articles, at Authorities 22.437, I said that whilst he broadly supported the judge's conclusions, he didn't support them unreservedly. And at the paragraph, the first full paragraph, he quotes the judge's judgment and says, "This does not sit well, however, with the supreme comments in the ever smart that Rule 14B and 13B contain a precise specification." He then quotes from Farrell and concludes by saying, "We do not find such reasoning at all convincing and believe that Rule 14B has been drafted with the same intention as Rule 13B, namely to fix the demarcation point with what will otherwise be considered a crossing situation." And that, in our submission, is the correct conclusion. And the judge erred in concluding that 14B was not a definitional provision. The second sub-issue that the learned judge dealt with was the and/or issue. And I've touched on this this morning. In one sense, provided we are right about the importance of the sidelights and the ahead being defined by the same arc, the and/or debate doesn't really matter.
Well, it may help us know whether you are right, though.
But my lord, I'm going to come on to that. Well, no, we've already addressed that as to whether we're right about the 3-degree arc. But if we're right on that, it's again part of the package. And/or follows. Put it the other way round, it would not be wrong to conclude that a head-on situation can exist based on masthead lights alone, provided the phrase "nearly in a line" is not widened beyond the scope of the sidelights. So if we're right on that point, then we wouldn't demur from the fact that you can look at just the masthead lights, subject to the difficulty I mentioned earlier to my Lord Justice Nugee about how reliable they can be at 8 miles, given the very small angular separation you will have at that distance. And so I'm not going to go back to it, but if I can just give my lords the references at page 455, 457 and 461 of the authorities bundle, and that's Captain Thornton's article. He expresses the same view, essentially, that it doesn't really matter if you say and/or would allow for either or both, provided you confine what is nearly in a line to the same 3-degree arc.
That's where I had difficulty with. I don't understand if all you can see are the 2 mast lines, how you marry up nearly in a line question with the 3 degrees, because what you see with the 2 mast lines is they're either on top of each other and one of them's a bit to the side. What 3 degrees? Is it the angular separation? Because if it's the angular separation, these angles are much less than 3 degrees.
The angular separation is much less. And
0.something.
Yes, my lord, it's tiny, which is why in our submission it's not a particularly reliable indication of whether the rule is engaged. But I'm making a different point. It's not the angular separation. It's still the relative position of the vessels defined by the 3-degree arc.
That's the ahead or nearly ahead point. But it doesn't tell you what nearly in a line means.
My lord,
Does it?
it does, because if you are within the arc, where you would be seeing both sidelights, so the 3-degree either side of the centre line arc, that is where you would see, that defines or prescribes nearly in a line. If you are beyond the 3-degree arc, so that if you could see the sidelights, you would only see one, then what you can see is not nearly in line of the masthead lights.
Well, on your interpretation, if you're within sight range of the sidelights, it's the sidelights. And if you're not, it's whether if you were, you could see the sidelights. The masthead lights aren't really doing a lot on your construction, are they?
My lord, they're not. I have to accept that. They're doing very little. But equally, we would make this point. If we're wrong, then what would be not a head-on situation when you could see the sidelights might be, depending on one's subject interpretation of what nearly in a line was. So it would not be the correct construction of the rules in our submission if you had vessels that were not carrying masthead lights, judge their position purely by the side lights, and then if one of them were carrying a second masthead light, so you could see if they were in line or nearly in a line, one came to a different conclusion about whether the rule applied. The answer must be the same in both cases, and it should not in our submission depend on a subjective understanding of what is nearly in line. It should depend on the relative location of the vessels, i.e., as the little plot I handed up shows, whether you are at the extremity of 3 degrees from the heading. And I accept that that reduces the value of the masthead lights in terms of the definition, but it increases the certainty. And what cannot be correct in our view is that a situation could be head-on as defined by the masthead lights, because a mariner or a judge and his nautical assessor considered that a particular separation was nearly in line when they were outside the geometry of the 3 degree limit.
It increases the certainty, but it might be said a certainty that's not there in the words used.
My lord, I have to accept that because of the reference to nearly in a line.
Because
but I still come back to the position that nearly in a line must have a meaning.
Yeah. I mean, you have to be right about that, don't you? That takes us back to the 3 degree arc, because the words are such a situation shall be deemed to exist when a vessel sees the other ahead or nearly ahead, and by night she could see the masthead lights of the other in a line or nearly in a line, and or both side lights. So on the words, if, contrary to your case, you read and or as meaning disjunctive, on the words you haven't got to side lights. On the words you don't get to side lights, you just get to masthead lights.
My lord, yes. Can I just on that?
I mean, that's right, isn't it? Just as a matter of the words.
My lord, just as a matter of the words. Yes. My lord, on that, can I
So
just...
you have to be right about in a line or nearly in a line. That submission has to be right in order for this point to work.
Right.
Yeah, I get the point.
And my lord, can I just mention that my learned friend, Mr. Cooper, KC, pointed out to me over the luncheon at Germans, and I hadn't spotted it. I said there was only one change between the convention wording and the rules as enacted. There is in fact 2, and Rule 14b has the word would rather than could. Would see rather than could
There's
see.
a mystery solved.
So that is probably why in some places we refer to would rather than could. So the convention says could, the UK enactment as it now is said would. What I will try to do before tomorrow is ascertain whether that's as it were, a frolic of our own, or it's because the rules were amended. All the other changes are because of amendments to the rules, and there is provision within the rules for them to be amended. So I will need to have a look at that.
So the text we've got in tab 13, I think, the authority fund, is not the text we should be looking at.
My lord, no, which is why it's in the supplemental bundle, which my lord does now have, and it's page 25, tab 2 of the supplementary authorities bundle, and that's where the would instead of could comes.
And what is your submission as to what the import of would is? Because if you say someone would see something, there's an unexpressed bit, which is if something else. Would see it if what? If they were close enough, or if they looked, or?
If within range, I think must be the answer to that question, my lord. Such a situation should be deemed to exist when a vessel sees the other ahead or nearly ahead, and by night she would. So if it were night, she would see the masthead lights.
Could you just give me that reference to the...
Tab 2, page 25, my lord.
Thank you very much. Tab 2.
Whereas Rule 13 maintained would throughout.
My lord, as I said, I will endeavour to find out the source of the change, and it may not have been in this version because there have been several since 1972. my lord, finally, I gave my lords the reference. Can I just actually turn up page? Page 455 of the authorities bundle.
Yeah.
455, Captain Thornton at the bottom left-hand column says the authors have no issue with the above, so that the learned judge's conclusion on and/or, provided the limit of when masthead lights being nearly in line is not widened beyond the arcs of the side lights. That essentially is our point, and then goes on to say at 461, under the heading determining the head-on situation, as touched on above, we do not have an issue with using the finding that the vessel can make an assessment using masthead lights only, e.g. when side lights are out of range, and to upturn the Rule 14 see if they have a doubt. But this should not widen the factual legal limit of Rule 14 beyond the arc of the side lights. And so, my lord, in our submission, the correct conclusion is that whilst it may be permissible to look at masthead lights as well as or instead of at the right distance, the side lights, that should only be if one maintains the strict still maintains the strict definition of what is in line or nearly in line by reference to the same arc. And my lords, I move on, if I may, to the third sub-issue, a vessel issue. This is another sub-issue which, in one sense, as I've already highlighted, doesn't arise if we're right on everything else because of the mathematics, the geometry of the fact that if we're correct on a head and correct on the arc of the side lights, then always both vessels will either be able to see both the side lights or only one side light when the other vessel is ahead, and that hopefully the little sketch makes that good. And again, there would be no problem with considering the a vessel issue and answering it as the learned judge did, provided one's consideration of the rule overall was still constrained by the visibility of the side lights. But the learned judge concluded that it would be sufficient to engage Rule 14b if just one vessel saw the other ahead and as described in the rule. Now, the first problem with that in our respectful submission is this. Even if that is correct, when AFINA I saw the correct aspect of KIVELI, so both side lights, it was not in the correct position. She was not ahead of AFINA I, she was to starboard. And that again comes back to how the A vessel issue pans out in relation to both vessels. But in any event, in our submission, the learned judge was wrong for the reason that Sir Nigel Tier gave in the MSc Apollo. We've looked at that already, and I don't propose to go back to it, but it's page 83.
This is the reciprocity point.
Indeed, my lord.
I mean, there may be a number of different answers to what on the face of it seems the good point, that to take the extreme example of vessels crossing at right angles, the fact that one of them can see both side lights of the other ought not of itself to be sufficient to create a Rule 14 situation. Are there other ways of answering it than Sir Nigel's answer? For example, treating the requirement of head-on, but without your geometric definition of that as itself a condition for one vessel to have to turn when it sees the two side lights, in which case I'd have thought it would be quite unlikely the other either would not similarly see it or at least be in a Rule 14c doubt scenario.
Well, my lord, the ultimate answer is the one my lord just gave, that one moves over into 14c when one vessel is in doubt. The headline answer, the more correct answer again, is to come back to the point I made to my lord this morning. One has to construe 14a and 14b together. They are concerned with the same thing, providing a precise trigger to the obligation to turn to starboard. And taking them all together, the limbs of 14b are part and parcel of the same test.
I think the respondent skeleton suggests Mr. Cooper accepts that on this particular issue, you look at 14a and 14b. So there may not be quite so much between the two of you.
My lord, no. But,
And you would accept that we'd have to construe a vessel in the same way throughout? Because, I mean, obviously in 14C, a vessel clearly means singular.
My lord, in 14C, a vessel clearly means singular. I can't escape from that fact, but nonetheless, read in the light of the requirement for reciprocity, 14B, as Sir Nigel put it, reading them together, it must be the inevitable meaning of Rule 14 that it has to be Rule 14B that it has to be satisfied by both vessels. In one sense, I mean, I see the difficulty because of the use of the language, but what Sir Nigel was doing was recognising my overarching submission, which is that by definition it always will be if it is a genuine head-on situation. And perhaps one doesn't need to scratch.
I mean, I think that may put the finger on it in that it may be that properly construed, the likelihood is objectively the other one ought to be taking some form of Rule 14 action, but to express its application for a particular vessel on an assumption as to what the other vessel can also see is slightly counterintuitive.
And that's a point the learned judge made, my lord. But the answer to it, with respect, is because you're not actually asking yourself what the other vessel can see, you're asking where you can see her. So if I'm on board KIVELI, I can see both side lights, but on a correct application of the rule as we say it, I can't see them ahead. I don't have to ask myself what KIVELI can see. Similarly, KIVELI can see only one side light ahead, but only one side light, and doesn't have to ask himself what AFINA I can see. Because if applying all the provisions together as a package, you've still got the situation that if you are outside that 6-degree arc, what we say is the correct definition of nearly reciprocal, then both the vessels won't be able to see both side lights. If you are within it, both the vessels will be able to see both side lights. And in that respect, Sir Nigel's answer is correct, even if there's a tension between his answer and the wording of the rule. My lords, I don't think there's anything else I can say in respect of those three sub-issues. If I can move on to Rule 14C, which I want to treat very quickly, if I may, for this reason, apart from the fact that it forms part of the learned judge's overall approach to the rule, I don't believe it affects the outcome of the appeal. In this sense, I don't believe it was either party's case at trial that this was a we were in doubt situation. Our case was it's a head-on situation. My learned friend's case was, sorry, our case was it's a crossing situation. My learned friend's case was it's a head-on situation.
That's relief. For momentarily, I thought possibly I'd misunderstood this case.
I hesitate to rise again, my lord, but just to be clear, it was our case below that if for any reason 14A and 14B didn't bring us home, our officer of the watch was in a position where he was reasonably entitled to be in doubt for the purposes of 14C, and 14C therefore, and Rule 14 therefore applied. And indeed, we had a discussion at the hearing as to whether it was enough that my vessel considered that Rule 14C applied to bring Rule 14 into operation, or whether the effect of my vessel being in doubt was that I should be treating it as a Rule 14 situation, but KIVELI was entitled to proceed on the basis it was a Rule 15 situation.
Well, my lords, I'm grateful for the clarification. I didn't intend to mislead, but I'll deal with the issue then as I was going to.
Yeah.
And our submission is this. The learned judge concluded at paragraph 187 that if one vessel was in doubt, so on this project, AFINA I, Rule 14C was engaged and that it compelled both vessels to take action. As my Lord Justice Coulson has already pointed out, the difficulty with that, if I'm in some difficulty with the use of the word a vessel in 14B, my learned friend is in even more difficulty with the repeated use of the word a vessel in 14C. It's not what the rule says.
Do you accept that the question is whether objectively a vessel in the relevant position ought to be in doubt, not whether?
My lord, we don't. And let me explain why. 14C is a provision that says to the officer on the watch, the rules are there to enable people to navigate their vessels. I mean, they have a function to enable the court to apportion liability if you breach the rules. But the rules are there to say, if you're in doubt, for example, all the cases give, if one vessel is yawing and one side light is coming into view and then out of view and into view and out of view and you're not quite sure, then you assume that the situation exists and you navigate accordingly, you turn to starboard. That's a very different matter from saying that if the officer of the watch on AFINA I is in doubt, the court should assume that a head-on situation applies and compel both vessels to turn to starboard.
Let's say the officer on the watch doesn't think about it at all, doesn't apply his mind, or is super confident. And is one of those types of people one occasionally has the misfortune to meet who don't entertain doubt, where any competent mariner would have said, well, on any view, that there's real doubt here as to whether this is a head-on situation. You say Rule 14C isn't engaged in those circumstances?
I do, my lord, and the reason is this, because that's not then a question of Rule 14C. It's a question of whether the mariner was exercising proper care, keeping a good lookout, appreciating the risk of collision. So his breaches of the rules is his failure to actually correctly appreciate whether it was head-on or crossing. One is talking of, and in some senses, it's a difficult debate because my learned friend says we were in doubt. The one thing he didn't do was turn to starboard until far too late, we say, but Mr. Carruth will deal with that later. But 14C is a permissive provision that says if you're in doubt as to whether 14B is engaged, then you should turn to starboard.
It's expressed in obligatory rather than permissive terms.
Yes, even as I said permissive, I realised what I meant by permissive was that it is a provision that reflects the fact that a mariner on the bridge may be in doubt that was not present in Rule 18. It tells you what to do if you're in doubt. But what it doesn't do is turn a crossing situation into a head-on situation. So if this is not within 14B, the fact that the officer of the watch on one vessel is in doubt doesn't turn it into a 14B situation. Apart from anything else, one can test the matter this way. If this is a crossing situation, KIVELI is obliged to hold her course and speed. She's the stand-on vessel. AFINA I is obliged to give way, take appropriate action to avoid the collision. If my learned friend is right, the doubt that his officer of the watch feels compels my officer of the watch to turn to starboard, even though he has no way of knowing that the officer on the watch on AFINA I is in doubt. If it is a situation where the court looks at the facts and concludes, in fact, it was a head-on situation, then the officer of the watch of KIVELI is negligent in breach of the rules for not appreciating that. But he's not in breach of Rule 14C for not being in doubt. This is a provision that is telling the officer of the watch on AFINA I what to do. It can't be telling the officer of the watch on KIVELI what to do if he believes it's a crossing situation. He may be negligent for believing it's a crossing situation. That's a different breach of a different rule. It's not a 14C situation. And so in our submission, the fact that AFINA I's officer of the watch is in doubt does not and cannot compel KIVELI to know that fact and take action accordingly. And that's why it's all expressed in the singular, my lord. There's no reference here to both vessels. There's no reference here to where a vessel is any doubt whether such a situation exists, it shall be deemed to exist, which would essentially be the provision my learned friend is arguing for. He's saying that this deems it to exist just because his officer of the watch is in doubt. That's not what the rule says. It says he, the OOW in doubt, shall assume. Nobody else is obliged to make that assumption. My lord, it's a simple point of construction and language. There's no travo here. There's no authorities either way to assist. I've set out our submissions, and I doubt if there's any more I can say if they don't appeal to my lords. I'll move on if I can.
So there's no authority on the doubt, shall we call it the doubt point at all?
Not that I'm aware of. My friend may be about to refer to one of the books, but
Well, I had in mind decided cases. There's no.
so did I, my lord, when I answered the question.
Fine.
So my lord, in conclusion, we submit that Rule 14 sets out the rule, turn to starboard. Rule 14b defines it, and defines it by reference to the side lights that are visible at night, and the equivalent aspect during day, and the equivalent aspect when only the masthead lights are visible. Can I ask my lord to have the judgment, paragraph 125, because there's a quote there from Captain Hurst, which we say, it's core tab 8, page 189.
Paragraph, sorry, you said?
125.
Thank you.
The learned judge quoted from Captain Hurst's book, and he says this: in calm conditions, one vessel should only ever see the masthead lights and both side lights of the other vessel when their courses do not differ by more than 6 degrees from the reciprocal. I think he must mean the masthead lights in a line or nearly in a line, because you're going to see the masthead lights come what may. If the other vessel is noticeably yawing, however, her masthead lights and both side lights may be visible on occasions, even though her course is more than 6 degrees from reciprocal. Her heading is oscillating, yawing either side of her course. And on certain headings, her masthead lights and both side lights may be seen, but not on others. And I think that must again mean masthead lights in a line or nearly in a line. There is accordingly potential for conflict when applying the various elements of Rule 14 for determining if a head-on situation exists. A vessel, however, is likely to have doubts about the precise course of the other vessel, where the other vessel is yawing, and therefore having difficulty maintaining a steady course. In these circumstances, a vessel should assume a head-on situation and act accordingly. So that's the vessel that's got doubts. So that offers some support on the...
Are the passages from Hurst that were placed before the judge in the authorities bundle before us?
They aren't, I regret, my lord.
We ought to see them.
My lord, I've set out extensively what our submissions are as the correct meaning. I don't think I can assist further by going over them again, but can I just remind my lords again of the passage from Captain Thornton's article at Authorities 23.459, which I took my lords to this morning, where he sets out what I described as the package.
It would follow the paragraph of 14.
Yes. My lord, yes. And my lord, for all those reasons, it is our submission that the learned judge should have concluded that 14b was a definitional provision, that the requirements of it, whether one looked at it from an a vessel point of view, from an and/or point of view, or simply as a matter of overall construction, the requirements of 14b are not satisfied, as they would not have been satisfied under Rule 18, and in that sense the Travo support our construction. They should not therefore be treated as being satisfied now. This was not and never was a head-on situation. The final point I need to deal with is the period of application if it was a head-on situation. And I can be, I hope, relatively brief about this. Rule 14b specifies certain matters which, if satisfied, lead to the situation being treated as a head-on situation. It's drafted such as to oblige both vessels to turn to starboard if they're meeting on the reciprocal, nearly reciprocal courses. It doesn't specify a period of application. But in our submission, if the definition is no longer satisfied, then the obligation in Rule 14A to turn to starboard is no longer engaged. The operative requirements of 14, the obligation to turn to starboard, don't have, we would suggest, a life of their own outside the defined circumstances. And there's no equivalent of Rule 13D, which provides that the overtaking situation shall continue until the overtaking vessel is finally passed and clear. And the learned judge concluded that once a head-on situation exists, it continues, and that subsequent changes do not affect that classification. And he held that it remained a head-on situation until the risk of collision had ceased. In our submission, it is not logical to say, well, if one of the ingredients of Rule 14, the risk of collision, has gone, it ceases to apply, but not if the other, reciprocal or nearly reciprocal.
Well, one of them might be thought to be a more significant enduring state than the other. But let me ask you this. If the side lights are visible and a vessel begins its starboard turn, presumably that process will pretty soon put one side light out of. Does that mean it can now cease continuing its turn to starboard because Rule 14B definition is no longer engaged?
My lord, my lord is talking about, on our case, for example,
Yeah.
before AFINA I crossed the centre line.
I'm just trying to work out, which of the definitions on your case, which of the elements of it can drop out of the picture
Well,
for Rule 14 to be disengaged?
my lord, if, for example, AFINA I had made a substantial alteration of course to starboard at C-22 when she believed on her case that there was a risk of collision and that it was a head-on situation, then there would come a moment where she had turned enough to starboard that 14A was no longer satisfied because the definition in 14B was no longer met.
Because I mean, Rule 14A contemplates altering course to starboard so that each shall pass on the port side of the other. There sounds to be an element of continuity, and presumably in the course of that, but before fruition, there will come a point in time when you won't be able to see both side lights of the other vessel anymore.
My lord, yes. I'm just trying to think through how it works, but
I don't have a diagram to offer.
but that would be, I suspect, at a stage where the courses were then diverging. So a port-to-port passing, but a widening CPA. I'm just struggling slightly to envisage.
It may be an unrealistic example. But your case is whenever any of the definitional elements ceases to be met, Rule 14, although once properly engaged, ceases to apply. That's what it comes to.
My lord, it is, and that doesn't detract from, as my lord put it, the seriousness of the risk of collision as being one of the elements, because the vessels will still have obligations under other rules to avoid the collision and take appropriate measures. My lord, can I test the matter this way on the facts of our case? I took my lords to the plots when I started my submissions, and I did so to show that the inevitable consequence of AFINA I turning to starboard after crossing our course line was to turn a bad situation into a far worse situation. And that essentially is the illustration, we say, of why the head-on situation cannot continue. Because it cannot be the intention of Rule 14 in a situation such as this, where we say the vessels have passed out of the head-on phase, to still require AFINA I to turn to starboard, when that necessarily requires the CPA to be reduced from one that is too small to one that is far too small, a ship's length or so. Except my learned friend's plots are based on when we did make our alteration to course, and maybe it was a bit more than a ship length if we'd made a starboard alteration earlier. But it cannot be correct that the rule continues, the obligation to turn starboard continues after the crossing phase, sorry, the head-on phase has ceased to exist. And my lord...
Why not?
Because it makes a bad situation worse, my lord, because...
But if both had turned to starboard, then there wouldn't have been a collision.
My lord, but there would still have been a far closer CPA than there would have been if.
That's to do with the timing of it, and I mean ultimately that's reflected in the judge's 20%. But you said that the rule couldn't continue to apply. I mean, just putting yourself in the shoes of somebody standing on the bridge. I mean, are you really scrabbling through? Oh well, I'm out of Rule 14 now, but it might be Rule such and such. Is that? I mean, that doesn't sound to me, as a landlubber, very realistic.
My lord, what we
We're working on the premise, aren't we, that because we're talking if 14B applies. I mean, appreciate that's contrary to all the careful submissions you've made so far today, but for this point, the length of the time, the period of application, we're assuming that 14B applies. So the point then comes, do you disapply it until after the ships have successfully navigated past each other?
My lords, the 2 points, it's 14A and B together.
You're right, 14A and B together, yeah.
Secondly, the phrase, if I can, I would use passed out of the head-on situation phase. And the reason for that is there's a case that my learned friend relies on, and the learned editors of Marsden quote on this point. It's Viscount Finlay in the Orduna. And he says that if it's a crossing situation, it continues to subsist. In our submission, what Viscount Finlay actually said was that the crossing situation continues to subsist until the vessels have passed out of the crossing phase. And in that case, the vessel that was crossing ahead, the vessel being crossed, that's a very unelegant phrase, turned to starboard too soon. So the vessel crossing her hadn't passed out of the crossing phase. The green sidelight of the other vessel was still ahead, or just moving out of the ahead. And the case is in our submission nothing more than a determination on the facts that the crossing situation hadn't ceased.
That phrase from Viscount Finlay is picked up in 5 or 6 subsequent collision cases, isn't it, where people essentially try and run the point, well,
the crossing
we're out of
phase,
this rule.
and that's why I consciously picked up on that phrase, because without going to the case, and I'll come to it in reply if I need to, without going to the case, all that Viscount Finlay was saying was that you have to assess whether, as a matter of fact, the crossing situation, or in our case, the head-on situation has been passed out of. To come back to my Lord's point, when, as a result of AFINA I crossing ahead of KIVELI's bow and opening to starboard, we say, and I took my Lords to the bearings and the relative reciprocals this morning, I'm not going to go there again, and sought to illustrate it. We say she's passed ahead, and a turn to starboard can only make the situation worse, even if KIVELI had also turned to starboard. And where rules are designed to promote safety at sea, it cannot be the case in our submission that is the correct construction of the rule. It was no longer a head-on situation because the necessary ingredients, whether it's 14A or 14B, no longer exist.
Any decided cases on period of application other than the Viscount Finlay reference?
There is the American authority that is referred to in a head note. If I can just go back to that. There's a note in Farrell about this, which the learned judge referred to at paragraph 153 of his judgment. And Farrell was referring to a decision of the United States District Court in a case called Gulf Coast Transit and the Anco Princess. And my Lords have that authority. So rather than looking at the roots of what it got to, if I can just go straight there, it's at tab 14 of the authorities bundle, 268. And this was a case which the learned judge relied on in support of his conclusion that once a risk of collision exists and the approach situation can be classified, subsequent changes, was the phrase that were used, do not affect that original classification. But if one looks at Anco Princess, the factual situation is that there was a vessel northbound in the Mississippi River and a tanker proceeding northbound and a tug and tow proceeding southbound. Essentially, the tanker mistakenly believed that the tug and tow were not leaving them enough room on the eastern side of the channel. And she turned to port to effect a starboard to starboard passing. The judge concluded that in fact the tug and tow were about in the middle of the river. And in fact the collision took place in the middle of the river. But the tanker's submission was, once we'd completed our turn to port, this was not a head-on situation anymore. Not surprisingly, the court concluded that a change, to use the judge's phrase, subsequent changes don't affect the original classification. All the court in this case was doing was saying, if you, one of the vessels in a head-on situation, when that situation exists, turn to port, you can't then say, well, now it's a crossing situation. You can't, by your own manoeuvre, turn it from a head-on into a crossing situation. But that doesn't meet our submission, which is that where both vessels do nothing and they pass out of the head-on phase, it is no longer a head-on situation. So it doesn't support, with respect to the learned friend's position, it's dealing with an entirely different point, which is whether if one vessel does change course, they can then rely on their own change of course to say it's a different rule.
Can be as much a conscious decision not to change a course as to change a course. Why do those two decisions attract different end periods for the Rule 14 head-on situation?
Because it's the consequences of the not changing. So it's not just, in the Anco Princess, it was the change of course to port that was said to create the crossing situation. In our case, what we're making is a different point, which is that both vessels having taken no action when on the posit they should have done, the head-on phase is then passed once they'd moved out of the geometric location with respect to each other that constitutes a head-on situation. In simple terms, the obligation to turn to starboard is engaged by the existence of certain facts, and when those facts no longer exist, the obligation is no longer there. And therefore, AFINA 1's turn to starboard was neither compelled nor justified by Rule 14. It's a separate issue from what she should have done, which my learned friend Mr. Carruth is going to deal with. Unless I can assist further, those are our submissions on grounds 1, 3 and 2, and Mr. Carruth will deal with apportionment.
No, well, thank you very much, Mr. Smith. Yes. So, Mr. Carruth, you're dealing, so that I'm clear, you're dealing with effectively the consequences, what you say are the consequences if you are successful on any of the grounds.
Yes, that's correct, my lord.
Because the apportionment ground simpliciter permission was refused on that by Lord Justice Popplewell. So what we're talking about is if you win on ground 1, then X.
Correct, yes. So the bulk of my submissions will be on that precise issue.
Yes.
If we win on grounds 1 and 3, then what's the consequence in terms of apportionment? Just to give you the other issues I'll also be addressing in order. First, the argument that we don't have permission to challenge apportionment situation. Second, that this court cannot apportion liability because it should do so only in exceptional cases. Thirdly, I think there was some suggestion last Wednesday morning that my learned friend's position will be that the court should remit if it finds there was an error of law and there needs to be a new apportionment exercise, that it should be remitted to the court below. I'm just going to touch on that briefly. Fourthly, the principles of apportionment. And then, as my Lord Coulson's already observed, the position if we succeed either on grounds 1 and 3 or on ground 2. Turning first to the issue of whether we lack the necessary permission, we've addressed this comprehensively in our supplemental skeleton argument, so I'm not going to say very much about it. The two short points are, first, we say we do not need permission. Nowhere in the judgment itself is it stated that the apportionment would be 80-20, even on the basis of a crossing situation. That comment was made only obiter in the consequentials judgment in the context of refusing permission to appeal. My lord, you look like you might have a question.
I'm not sure that characterising it as obiter, it would always have been an alternative to a primary finding, nonetheless, if it had been made in the course of the main judgment. Obviously, the judge, I think you recognise, does say that. I can see you may say, if we change the ground rules, that appears rather unlikely outcome, but why doesn't the test for overturning first instance evaluations applied to that, simply because the judge deals with it at the consequential stage?
Well, in my submission, my lord, it's a very different thing to say in the specific context of refusing an application for permission to appeal, months after the original trial and the original judgment. Well, I think I would have found the same anyway, even if it had been a crossing situation. I accept the judge expressed in trenchant terms that that would have been his view, but it's, in my submission, not a point made with the same degree of thought and consideration as if it had featured in his original.
In fairness to the judge, it doesn't come from nowhere, does it? Because there are quite a few passages in the main judgment itself, which I think, say, even in a crossing situation, particularly impressed, I'll put it neutrally, by the seamanship shown on the KIVELI side.
It is true to say that he makes, he runs through rules 15 to 17 in the main judgment and makes observations about what the position would have been. But the key point for present purposes is nowhere in the course of that judgment does he say this would be 80-20, even if it was a crossing situation. But even if we do need permission, my lord, in my submission we have it. It was abundantly clear from our appeal documents, by which I mean the appellant's notice, grounds of appeal, and the skeleton argument in support, that we challenge the apportionment that, well, if it's a crossing situation, we say it would not be an 80-20 apportionment. For example, ground 3 of the grounds of appeal says expressly the judge should have appealed on the basis that it was a crossing situation.
But for my part on that point, I entirely see you didn't come here to argue some moot points on the collision regulations if they were incapable of affecting the outcome, but there may be a separate issue of the test this court has to apply if the judge has in fact addressed himself to it first instance.
Well, that I think brings me to issue 2, my lord, which is I think the exceptional case point. And there are really 2 points there. The first is this: the legal principle is this: an appellate court should not lightly interfere, or should only interfere in an exceptional case if it finds no error of law or fact in the judgment of the court below. If this court finds itself in the position of apportioning liability, then by definition it must have found that there was an error of law in the judgment below. But in any event, my lord, we say it doesn't really matter because this is an exceptional case. If we have to meet the exceptional case test, it is met on the facts of this case. The view that if this was a crossing situation, the correct apportionment was 80-20 in AFINA I's favour is, with respect to the learned judge, well beyond the range of reasonable opinion. There is simply no world in which, if this was a crossing situation, AFINA I is not substantially more to blame than KIVELI. So if, my lord, you find that we do need to meet that test, then I say unhesitatingly
it's enough for your purposes if there's no world in which you're in exactly the same allocation of blame as you would be if it was a head-on situation, because you would have changed the ground rules to a very significant extent. It might be thought surprising if they nonetheless ended up in the same answer.
Precisely, my lord. I'm sorry, I didn't quite hear the beginning of that. But yes, if the ground rules have changed fundamentally, and as I'll be coming on to, the obligations of the 2 vessels were fundamentally different, it would be surprising if we arrived at the same apportionment.
It may not ultimately matter very much, but just going back to your first point about it being in the consequentials rather than in the body of the substantive judgment, there is authority, and I'm sorry I can't remember the name of the authority, but there's an authority where the Court of Appeal considered that that was part of the judge's reasoning, and therefore the test that, I mean, the sort of test you just articulated would apply, so that it ultimately it doesn't matter where the expression of that particular opinion is.
And they're handed down on the same day, aren't they?
They are handed down on the same day, albeit the dates between the original trial, the date on which the judgment in draft was provided to the parties, and the date of hand down of the two judgments are slightly different, because there was, of course, the protracted process dealing with the assessor's advice and responses to the advice.
Yeah.
As to my Lord,
I mean, I only remember that, freely confess, I was the judge. So at first instance, and it's a decision of the Court of Appeal, it's Mr. Justice Jackson and two others. I'm terribly sorry, one can never remember the names of one's own cases, but if you can find it, great. But I don't think that doesn't really affect the principal point that you're making under this head.
Correct, my Lord.
Yeah.
And I mean, I'm not familiar with the authority you've referred to, my Lord. It might be conceptually that there's a difference between providing further reasons in a consequentials judgment for what might be described as the ratio of the original judgment, and making, I hesitate to use the word obiter again, given my Lord Justice Foxton's earlier observation, but an obiter comment about what the outcome.
I'm afraid I simply can't remember. Obviously, they were both masterpieces, but I can't remember the particular point.
Can I just pick up this obiter question? I mean, it's very common for first instance judges to say, I find this, and on my understanding of the law, that's enough to dispose of the case. But in case I'm wrong on the law, I'm now going to go on and find that.
Yes.
What is the status of the latter bit of the judgment? Because I would have thought if it's a finding of fact, and an apportionment is a sort of finding of fact, I mean, it's an evaluative assessment of who's responsible, but there's no law involved. It's a factual question in certain situations. I would have thought that the appellate court should have as much reluctance to intervene and overturn a contingent finding of that sort, as it were, as the actual findings on which the judgment is based. But by your use of the word obiter, you suggest it should have some lesser status. Is there any learning on that that you're aware of? What do you say the position is? This is obviously a quite separate point from where you find it.
Yes.
But suppose in his original judgment he'd said, I think this is a Rule 14 case, and in that case I assess it 80-20 for these reasons. If I'm wrong and it's a Rule 15 case, I still assess it as 80-20 for those reasons. Is the latter part really to be described as obiter, or is it? It's got some other status.
Well, my Lord, a few points there. First of all, if we're talking about findings of primary fact, then of course those are just the findings of primary fact. There's no obiter or ratio, those are just the factual findings. That's not what we're dealing with here. We don't challenge the findings of primary fact in the judgment. As for apportionment, it's not exactly the same as a finding of primary fact. I accept that it is an exercise of balance and taking into account competing factors. But if, for example, one looks...
I think the vogue word is evaluative assessment.
Evaluative assessment, yes. If one looks at the reasons given, for example, in the Koenig and Juliana for why this court or an appellate court should be slow to interfere in the absence of an error of law or fact, the reasons that are given are, for example, that the trial judge has immense experience of dealing with cases of this sort. Well, meaning no disrespect to the learned judge, that does not apply here. Number two, the trial judge will have heard lots of live evidence and have the temperature of the room, as it were. Well, again, not the case here. There was only one live witness at trial it is abundantly clear what the trial judge thought of that witness from the judgment. And as I say, we don't ask you to depart from any of the findings of primary fact that were made in relation to that witness's evidence. As to the question of what about if a judge says in a judgment on this version of the law, the outcome is X, but if I'm wrong about that, then it's what, and it's Y, as in the legal position is Y, then this is the outcome. In my submission, it is appropriate to describe that as obiter because it's simply considering something that it was not necessary to consider in order to arrive at the outcome that has been arrived at. It's ancillary. It's something that the judge did not necessarily need to consider. The judge in this case did not need to consider rules 15 to 17. He could simply have said.
No, but I find this a slightly surprising submission because having been in the position of the first instance judge, the reason you go on and say, I think the answer is X, but if I'm wrong about that, then here's a whole lot of other things that I'm going to say, is precisely in case the Court of Appeal thinks you're wrong on the law, and therefore you address what the question would be if the legal landscape were different from what you've found it to be, to avoid a situation in which the Court of Appeal either has to do the work itself or send it back for you to make, or someone else to make more findings. In other words, I'm a bit surprised to discover, if it is the case, that all those bits of the judgment which follow your actual decision, which say this is what I would have decided if, are to be ignored or given very little weight or treated as just passing comments, because that's not why they're done. First instance judges put quite a lot of work into them sometimes. Sometimes they don't, but sometimes they do.
Yes, my lord. I mean, as you say, ordinarily it's making the necessary findings of fact in case an appellate court takes a different view of the law.
Or to try and make it difficult to appeal the case.
Or to insulate oneself from appeal.
Or in defence of first instance judges the world over, to try and answer the questions comprehensively that the parties have asked him or her.
Absolutely, my lord. But I mean, with respect,
I mean, the advice one gives to first instance judges is decide everything.
yes.
I mean, you said it wasn't necessary to decide it, but that wouldn't be the advice that you'd give a judge. You'd say, well, deal with everything.
I understand all of these points, my lord, but fundamentally the question is, does that mean it is necessary, specifically in the notice of appeal, to impugn such matters, or is it sufficient to impugn the conclusion that is arrived at? As I say in my submission, it's the latter, but in any event, we have the permission we need. Lord Justice Popperwell's order granting permission expressly acknowledges the fact that apportionment might be affected if we succeed on grounds 1 and 3, or indeed 2. Well, he just says apportionment might be affected if the appeal succeeds.
Yeah.
And as I say, in terms of the test for when an appellate court should get involved, if it's necessary for this to be an exceptional case, I say it certainly is. Moving on to the next issue, whether this court should apportion or remit. I don't yet know precisely what my learned friend is going to say about that, so I'm not going to say very much about it at present. But in my submission, this court should not remit to the court below if it finds that there has been an error of law. It should perform the apportionment itself. I say that for the following reasons. First, it is not the usual position to remit. It is true that in the Eversmart, the Supreme Court remitted the case upon allowing the appeal to Sir Nigel Tier to reconsider the issue of apportionment. But it is expressly stated in the judgment that that was because that was the party's preference. That is paragraph 148 of the judgment. I have searched for and can find no other example of an appellate court remitting to the Admiralty Court upon allowing an appeal. I am reasonably confident there has not been one for the last 50 years, slightly less confident about the period longer ago than that, but as far as I'm aware, having looked, there is no such authority. Examples of where the appellate court has substituted its own apportionment can be found in the Kossia Zinia, 1996, second volume of the Lloyd's Reports, page 124, and the Noe Sachs, 1979, Queen's Bench 236. My second submission is that in this case, the appellate court is just as well placed as the court below to apportion. I've essentially already made most of those points in the context of earlier submissions. With respect to the learned judge, he is not the Admiralty judge. As far as we know, this is the only collision action he has tried. We do not challenge any findings of primary fact. We only ask you to make the one additional finding in relation to the sidelights. There was only one live witness at trial, and indeed, there is no dispute as to the manner in which the vessels were navigated, by which I mean what courses they followed, when their headings changed, etc., because that is conclusively demonstrated by the agreed data and formed the basis both of the agreed statement of facts, which is in the supplementary bundle, and the factual section of the judgment, as the judge acknowledges at paragraph 36. Issue 4, the principles of apportionment, and I'm going to take these quite briefly because they're not in dispute. But if I could ask your lordships to turn up the judgment at paragraph 321, which is page 239 of the core bundle. And the judge summarised the relevant principles in paragraphs 320 to 325. I'm not going to read those out, nor am I going to ask your lordships to read them now, but I would ask you to read that section in its entirety before writing your judgment. It summarises the principles and provides some relevant background to those principles. But I do just want to look at paragraph 321, where the judge summarised the principles set out by Mr. Justice Tier in the Nord Lake and the Sea Eagle. And I would emphasise in particular the first principle. That is to say, this is not about the number of faults on one side or the other. It's the nature and quality of faults that matters. The second principle, breaches of the obligations imposed on ships in certain defined situations by the collision regulations will usually be regarded as seriously culpable. One such rule is the narrow channel rule. I would submit another is, the crossing rules, and in particular the duty imposed on the give-way vessel, which I'll come to in a moment. And the fourth principle, in most cases, though not all, it will be right to treat the fault of a ship that creates a situation of difficulty or danger greater than that of the ship which failed to react properly to such situation after it has been created.
Good language. To treat the fault of a ship that creates a situation of difficulty or danger greater.
I think it's missing the word as greater.
Yes.
And that latter point comes from a case called the Maloja 2, which is in the authorities bundle at tab 5. Given the time, I'm not going to take you
Well, if these are agreed principles, then
precisely.
We don't need to drill down into where they come from if they're agreed.
Indeed, I'll simply state the one other point that arises out of the Maloja 2, which, as I understand it, is not in dispute, but which I was going to mention, is that in that case it was said, first of all, as we've just seen from the Nord Lake and the Sea Eagle, errors leading to a close quarters situation are usually more blameworthy than errors made on the spur of the moment, is the phrase used in the Maloja 2. And secondly, that is particularly so if the last minute action was thought to be the correct action at the time and only shown to be wrong with hindsight. And in that case, the judge said, I'll just give you the reference, it's page 57 of the report, right-hand column at Authorities Bundle, tab 5, page 37. And that is where Mr. Justice Sheen made that point. Turning to the apportionment if this was a crossing situation, first of all, I just want to take your lordships to the relevant collision regulations, which are in the supplementary authorities bundle, I think is the version we're now using at tab 2, or indeed the main authorities bundle at tab 13. But in the supplementary authorities bundle, it's tab 2, page 25. And the relevant rules are rules 15 to 17. I'm just going to paraphrase what they say. Rule 15 says that where two vessels are crossing so as to involve risk of collision, the give-way vessel should keep out of the way and avoid crossing ahead. It is, as I understand it, common ground in this case that at C-22, if it was a crossing situation, AFINA I was the give-way vessel.
Is that also the case at C-7.5 on your alternative ground 2?
Under the alternative ground 2, it is not a crossing situation
Ever.
at C-745. And if I have time later, I'll illustrate that by reference to the plot. But if one looks at the position at C-745, which is position 7, I think, off the top of my head, then neither vessel is crossing the other's course. Neither has the other vessel on her starboard side, and they're not shaping to cross. It's not a crossing situation.
What are we being asked to do if you succeed on that bit of your case, but not the rest of it?
Well, in a nutshell, our case, if that is the hypothesis, as in ground 2 succeeds but 1 and 3 don't, is that up until C-745, both vessels have been equally to blame because they ought, up to that point in time, have both turned to starboard under Rule 14, but haven't. Then one looks at the position at C-745, as I say, through the lens of both vessels so far being equally to blame. And we say the problem that then arises is that AFINA I turns to starboard, and actually what both vessels ought to have done in that situation was hold their course. If they had done so, they would have passed clear of each other at a not ideal but sufficient distance. But because AFINA I turns to starboard at C-515, that sufficient passing distance is, no matter what KIVELI does at that point, substantially reduced, and a dangerous close quarters situation results. So in that situation, my lord, I say head on up to C-745, and then after that it is simply a matter of rules 2 and 8, as in seamanship, and the action that ought to be taken to avoid collision under Rule 8. Coming back to the crossing rules, Rule 60, I've covered Rule 15. Rule 16 says that the give-way vessel must take early and substantial action to keep well clear. Rule 17 then addresses what the stand-on vessel must do. As I say, that's KIVELI on this hypothesis. Under Rule 17A1, she must hold her course and speed. That is the obligation of the stand-on vessel once a crossing situation arises. Under Rule 17A2, the stand-on vessel may take action. I emphasise the use of may in that rule, as soon as it becomes apparent that the give-way vessel is not taking the appropriate action to keep clear. And under Rule 17B, when the stand-on vessel finds herself so close to the give-way vessel that collision cannot be avoided by the action of the give-way vessel alone, the stand-on vessel shall take such action as will best aid to avoid collision. Finally, just over the page, Rule 17D states that this rule does not relieve the give-way vessel of her obligation to keep out of the way. That emphasises the unqualified nature of the give-way vessel's obligation. Unqualified nature was an expression used by the Supreme Court in the Eversmart Now, I drew your attention a moment ago to the use of the word may in Rule 17A2, as in on the wording of the rule itself, it is permissive, not mandatory. It does not, on its wording, require action. We accept that there is authority from this court that in some circumstances the obligation of seamanship can require a stand-on vessel to take action before the time at which Rule 17B is engaged, despite the permissive language in Rule 17A2. I just want to show your lordships what the Supreme Court said about that in the Eversmart, which is in the authorities bundle. Actually, sorry, if I could go first to the case that that principle arises from, which is tab 9 of the authorities bundle. It's the Eversmart when it went back to Sir Nigel Tier to reapportion liability. It's tab 9, page 128. And just at paragraph 118, I could just ask your lordships to read that. We don't have the case itself in the bundles, but this is an accurate statement of the principle. And then if I could show you what the Supreme Court said in the Eversmart, which is tab 8, page 83, paragraphs 66 and 67. And Lords Briggs and Hamlin said, attempt was made by the respondent to use Rule 2, that's the general obligation of seamanship, as the basis for justifying a complete disapplication of the crossing rules as a matter of construction on the basis of an apparent conflict with the rules of good seamanship, or to treat good seamanship on its own as a sufficient alternative to the application of the crossing rules. In relation to both of the questions before the court, we regard this approach to Rule 2 as being misconceived. First, it is plain from Rule 2A that compliance with the rules is a first principle of good seamanship. And then you'll see at paragraph 67, secondly, Rule 2B builds in an inherent flexibility to meet particular dangers and special circumstances, which points away from an approach which simply disapplies a rule as a matter of construction, because on particular facts, strict compliance may give rise to difficulties. Rule 2B contemplates not the disapplication of a rule as a matter of construction, but justifies a limited departure from its requirements, and only in particular circumstances which meet the stern test of necessity to avoid immediate danger. And that last bit is, in my submission, the crucial bit. So yes, we accept that sometimes a stand-on vessel can be required to act before 17B kicks in, but in my submission, the proper or the only way to reconcile the principle from the Acosia Zinnia with the permissive language in Rule 17A2 is that that only arises where it is necessary to avoid immediate danger. I'm just going to run through what we say the faults of both, particularly AFINA 1, were on the assumption that it was a crossing situation. First, the navigation of AFINA 1. Number 1.
You can do this by reference to the facts, presumably.
What do you mean by reference to the facts, my lord?
In the judgment.
The findings of primary fact.
Well, if you're listing a list of faults on the part of AFINA 1, those ought to be derivable from the judgment, oughtn't they? Otherwise, we'll be making those findings of fact if we agree with them.
Well, in my submission, my lord, what we're asking you to to do is an exercise of apportionment.
I understand that, but that's based on fact.
Correct.
So if you're asking us to make findings of fact,
We're not, my lord.
right, well then
The
you
only
don't
fa-
need to list faults, do you?
Well,
Because the
what-
faults you'd ask us to find as a matter of fact that there was fault X or fault Y.
what
And
I-
immediately, you know, the antennae twitch, because if we here loyally note down all that you say, we have no barometer by which to test that if it's not derivable from the judgment.
Well, it's derivable from the primary facts in the judgment, my lord. It's the application.
That's why I say, presumably we can, you can do this exercise by reference to the judgment. It shouldn't, what I'm saying is, it can't possibly be de novo in the Court of Appeal.
Well, it's not de novo in the sense that we don't ask you to make new findings of fact, save, of course, in relation to the sidelights. In terms of what each vessel did and when, we fully accept the primary facts as found by the judge.
Yes.
What I'm asking the court to do is apportion liability by applying rules 15 to 17 to those facts.
Yes.
And
And
these-
that's not something that the judge has done.
in the judgment, no, my lord.
Well, if it's not in the judgment, then it's not something the judge has done.
Precisely, my lord.
And if we got that wrong, then the route of appeal would only be to the Supreme Court,
Correct, my lord.
which would be most unsatisfactory if it can't be anchored, pardon the pun, back to the judgment.
Well, it can be anchored back to the judgment, as I say, in relation to the facts, but it is perfectly open to this court to take a different view on apportionment based on those facts. my
But
lord.
it would require findings of fact, findings of fault in this case, which have not been made before.
Yes, my lord, it would. But that is, with respect, my lord, the usual course of events. If one looks through history at collision
Well,
cases.
you've cited two cases, one from the 70s and I can't remember the other.
Well, yes.
I don't think any of them are from this century.
No, they're not, my lord.
So I don't think usual course of events is a particularly safe description. I mean, I think that the thing to do will be that we will note the findings of fault you want us to make, but provided that it's clear that we note those down without any, as it were, obligation or promise that those would be matters that we would even consider.
I understand that, my lord. Just to go back to whether it's the usual course point, I gave you the two examples of where an appellate court has allowed an appeal and then substitute its own apportionment. There are, of course, other cases where appeals have been dismissed because the appellate court decided that the apportionment at first instance was correct, or at least not sufficiently wrong that they were going to interfere with it. But
Yes.
that inevitably involves the appellate court taking its own view on the correct apportionment to arrive at that conclusion.
Not necessarily, because the appellate court might have decided that the attack on the findings of fault didn't meet the potentially high test that my Lord Justice Foxton was talking about. So I think it's not an area in which we would tread anything other than incredibly lightly, for the reasons just really canvassed. So you're going to note the findings of fault, not in the judgment, that you ask us to make. Yeah?
Yes, my lord. Well, it's a mixture of. Well, yes. Let me just give you the faults that we say the court should find. First of all, AFINA I did not keep clear. She did not. Sorry, AFINA I did not keep clear.
And I think that can't be in dispute because its case is this was a head-on situation and it wasn't obliged to.
Indeed. What she ought to have done was turn to starboard at or soon after C-22 when the crossing situation arose. Not only did she not keep clear, she crossed ahead, again in breach of Rule 15, which required her not to do that. My learned leader took you through the plots earlier, which illustrate that. She crossed ahead at about C-minus 1330 at a distance of about 5 nautical miles. Having done that, we say that she ought to have turned to port, or at least held her course. In fact, we say she should have turned to port to keep well clear, but did not do that. Instead, what she did is turn to starboard at C-minus 515, which, as I've already said, reduced a passing distance of 500 metres down to either 180-something metres or 66 metres, depending on whether KIVELI's response was to hold her course or to turn to starboard. Those numbers come from the plots in Annex 1 of the judgment. But in any event, it substantially reduced the passing distance, no matter what KIVELI did in response. We say that was the most blameworthy fault and the one which caused the close quarters situation. That brings me back to the principle from the Maloja 2, which I referred you to earlier, my lords. To make matters worse, she made no sound signal, as she was required to by Rule 34A when she turned to starboard.
And that there is a finding to that effect.
There is a finding to that effect, which is in the judgment of paragraph 80, my lord. Yes, the finding is, well, it's certainly a finding that no sound signal was made, and I think it's also a finding that it was a breach of Rule 34. She made a slow, gradual turn. Again, that's from the judgment, paragraph 70. That would not have been readily apparent to KIVELI and was a breach of Rule 8B of the collision regulations, as the assessor below advised.
I'm sorry, Mike, I hate to rise, but that factual circumstance has just been put to you.
Sorry.
I hate to rise again, my lord, but that factual circumstance has just been put to you in a way which suggests that the turn to starboard was not apparent to KIVELI. It was the evidence of the officer of the watch of KIVELI, and it was accepted by the judge, and I will find you the paragraph of the judgment, that KIVELI did see our turn to starboard, and yet did nothing.
Well, I'm sure, Mr. Cooper, you're making a note of this list, and obviously you can deal with each of the points.
The factual finding at paragraph 73 of the judgment is that KIVELI saw the turn at C-4, so a minute and a quarter or thereabouts after it commenced. But it was also found to be a stilted turn, and in my submission the relevance of that is that if it had been a bold turn, it might at least have been observed earlier than it was, likewise if a sound signal had been given. Coming on to KIVELI, her obligation, as I said, at C-22 was to hold her course and speed under Rule 17A1. She did that, apart from the nibbles to port, as they've been termed, at, well, between C-14 and C-8. The factual finding in relation to those nibbles is in the judgment at paragraph 59. We do not challenge the finding that those nibbles were inappropriate. We simply say that they were not causative. The vessels were at that time still more than 5 nautical miles apart, and their effect was to increase the passing distance. Under Rule 17A2, KIVELI was permitted to take action when it became apparent that AFINA I was not taking the necessary action to keep clear. I've already addressed you on permissive versus mandatory, and I say until it became necessary to take action to avoid immediate danger, she was not required to take action under 17A2. That cannot, in my submission, have been at any time prior to C minus 5:45, when AFINA I made her turn to starboard, or in fact, more accurately, when KIVELI observed that turn at C minus 4. The judge's view was that KIVELI should have turned to starboard at between C minus 22 and C minus 14. In relation to C minus 22, well, that can't be right because her obligation at that point in time is to hold her course and speed under 17A1. Shall hold her course and speed. The crossing situation on this analysis has only just arisen. That's her obligation at that point. As for C minus 14, AFINA I has not yet crossed. She's still 6 nautical miles apart. There's still time for her to take the necessary action. So, as I say, at the earliest, seeing the turn at C minus 5:45 would be when it might be necessary to take action.
So that involves effectively a finding that's contrary to the judge's finding.
Yes, my lord. It involves you saying the judge was wrong to conclude that at C minus 22...
As a finding of fact.
Well, I don't accept, my lord, with respect, that it's a finding of fact as such. It is a finding as to what a vessel ought to have done at a particular time. That is a matter of putting together the primary facts and the collision regulations. But yes, I do say the judge was wrong to conclude that action should have been taken at C minus 14 or earlier by KIVELI. Similarly, Commodore Dory in the court below's advice in answer 11 was that KIVELI should have taken action, not just was permitted to take action, should have taken action as soon as it became apparent to her that the vessel required to get out of the way was not taking appropriate action. That, I say, is wrong for the same reason, and it is, we say, impugned in our skeleton argument in support of the permission application. See paragraphs 70.4.
I think the principle is accepted that there can come a time when, because the other vessel's not doing what they're meant to do, you have to do something.
Yes.
The debate here is as to possibly the test as pure necessary, or if not the test, then that's
when?
An out-and-out attack finding on an evaluative judgment by the judge.
It is, yes.
Right about the test, that might provide you with an entry point, but if not, then you have to say...
That's right. Yeah. I don't shy away from that. It does involve us saying that the judge's evaluation that action should have been taken by KIVELI at C minus 14 or earlier was wrong. Rule 17b, we say, can only be engaged in the last 1 to 2 minutes. We've explained the basis for that in our skeleton argument at paragraph 70.5. That's paragraph 26 of the core bundle. It's essentially based on a calculation based on the length of the giveaway vessel.
Insofar as it's not a case of the judge applying the wrong test, but where the judge has relied upon the advice of the nautical assessor and accepted that, you then potentially get into that interesting question about what the test is for impugning the advice of the nautical assessor.
Yes, my lord, but on any view, so that, I mean, that's the Savina point, if I can call it that. And on any view, in the Savina, it was acknowledged that one situation in which it would be permissible to ask assessors in the court, in an appellate court, the same questions as those below, is if it's impugned in that case, I think it's the notice of appeal is the expression used. We do say it is impugned in our appeal documents, primarily I accept in the skeleton argument, but it is clear from those documents that we do not accept the judge's conclusion that action should have been taken at C minus 14 or early. Just finally on the turn to port at C minus 120, we accept that with the benefit of hindsight, that might not have been the right course of action. I took you to the passage in the Malota 2. We say that's a hindsight point. It was action taken on the spur of the moment in response to a situation of danger created by AFINA 1, and therefore it ought not to attract blame. And just overall, in summary, my lords, I would say this. First, the judge's approach, with respect, reverses the obligations of the two vessels under the crossing rules. He finds, or he says in effect, that KIVELI should have taken action earlier if it was a crossing situation, but AFINA 1 might have done. And as I say, that reverses the position. KIVELI was the stand-on vessel. It was for AFINA 1 to take early, bold action to keep it. And I say the only available conclusion, if it were a crossing situation, is that AFINA 1 was substantially more to blame than KIVELI, and the 80-20 apportionment that the judge indicated would have been his view if it were a crossing situation is, in my respectful submission, obviously wrong. I think I addressed you as much as I need to earlier on apportionment. If it ceased to be head-on at C-745, I'll deal with that further in reply if necessary, unless I can assist your lordships further. Those are my submissions.
Well, I think the obvious point is many of those points are expressly stated in ground 4, for which you didn't get permission.
Yes, my lord, that's correct.
So that's another hurdle. You haven't got permission for, I mean, there's a whole load of points, some of which you haven't made, but many of which you have under ground 4 apportionment, which Lord Justice Popplewell said strayed too far into the purview of the trial judge and the nautical assessor below and refused permission. So what do you say about that?
Well, so Lord Justice Popplewell, my lord, said that, well, he refused permission under ground 4 on the basis that if there was no error of law in the judgment, then the 80-20 apportionment was, you know, at least not sufficiently wrong to justify an appellate court looking at it. But it doesn't follow in my submission that absolutely every particular we gave in support of that ground was rejected and permission refused to run it. I mean, it's, with respect, my lord, a very technical reading of our appeal documents to say, well, that appears under ground 4, therefore it can't be raised. Ground 3.
I'm sorry if that's technical. There are very few things that you can hang on to in this job, and one of them is the grounds of appeal. And if you have permission, then fine, and if you don't, then fine. So you say, therefore, do you, that these points arose in ground 4 as it were, freestanding points, but you say you're still entitled to raise some of them, or the ones that you've raised, because they are the consequences if you're successful on 1 and 3 or 2.
Precisely, my lord.
We then have to be persuaded that on this hypothesis, the judge's error of law on grounds 1 and or 2 have a bearing on the finding that he's made that you wish to challenge, such that if those errors had not been made, that somehow undermines the reasoning process that led to the conclusion. It can't be enough simply to say, well, an error of law gives us a free hit on any point in the judgment. There's got to be a connection between the two, doesn't it?
Well, my lord, you would have to form the view, obviously, that that the indication he gave in the consequentials judgment about the position, if it had been a crossing situation, is not the right view. Of course, you would have to reach that conclusion. Yes. In relation to my Lord Justice Coulson's point, if I could just, I'm sure you've already looked at it, my lord, but ground 3, the page before, well, the same page that ground 4 starts at page 123 of the core bundle. Ground 3, existence of a crossing situation, final sentence, liability should therefore have been apportioned on that basis, i.e. that it's a crossing situation. As you yourself observed earlier, my lord, plainly we didn't come here to just say 80-20 is right, but for a different reason. We came here because we say 80-20 is wrong. And then if I could
I
just...
assume that ultimately money is at the root of the appeal.
Yes, of course, my lord. And if I could just give you the paragraph references to our skeleton argument at the permission stage, as in the skeleton that accompanied the grounds of appeal. I think it's paragraphs 70 and 73 in particular, which are pages 146 to 147 of the core bundle.
Hold on.
Sorry, specifically it's paragraph 73.
Paragraph 73.
Yes, 70 and 73. In fact,
Oh, 70 and 73.
Yes, sorry for the confusing
yeah.
reference. And at 70, we say, we run through exactly what I just said in terms of what we say the vessels should have done. This is all under ground 3.
Yeah.
We deal with when, if at all, KIVELI was required to take action under 17A2. And then at 73, we bring it all together and explain why, in detail, why we say AFINA I was substantially more to blame than KIVELI. So I would just invite you, my lord, to read all of those reasons that we gave at the permission stage.
Yeah.
I accept if the court forms the view that the law procedure requires a specific ground of appeal, challenging the judge's comments about apportionment if it was crossing, we might have a problem. But I say, my lord...
But you say the last sentence of ground 3 effectively achieves that.
Precisely.
And you say that 70 and 73 made plain the scope of the challenge. So your answer to my question is, well, we accept we have no right as a freestanding challenge, but to the extent that we're right on any of 1 to 3, then we say the door is opened.
Yes.
And you made your submissions as to what you say the consequences are.
Precisely.
Yeah, I understand.
Can I ask you, I've made a mistake. Have you given us a figure?
I had been intending to abide by the convention that one does not give a figure.
Is that right?
Well, these days some people do give figures. Conventionally, one doesn't. In the same way
you
that...
just say it's mostly their fault and leave it up to us.
Precisely. In much the same way that a prosecutor doesn't express a view on sentence. They simply give you the guidelines and the mitigating and aggravating features and then say, over to you, judge, and then appeal you when you get it wrong.
Well, the difficulty with that, of course, these days is that guidelines are so specific that within a band of a year or two, you are telling the judge what that sentence should be. But we understand. So the convention is that you don't give an apportionment.
If the court would be assisted by that, I am happy to do so. But as I say, the convention is
at the moment, Mr. Carutho, if that's your position, then we understand it, and it's a matter. You say it's a matter for us.
Perhaps if I can simply put it this way, it would be closer to, if not 80-20, the other way round were it crossing.
So I thought that might be what you said.
Unless there are any further questions, those are my submissions.
No, thank you very much. That's very clear. Yes, Mr. Cooper, I'm sorry it's a slightly disagreeable time of the day to be starting, but...
I'm rather hoping that this is that time of day where if I make a hash of it now, I've got time tomorrow.
It's all recoverable tomorrow.
Cover it.
Yep.
I'll set out in a moment a roadmap, but just to go back to the last question that my Lord Justice Nugee asked. First of all, I do not accept that in this day and age there is a convention that in collision actions you do not provide guidance to the judge as to what the appropriate apportionments are, not least in circumstances that occurred in this case, which is where, as I fully accept, the Admiralty judge was not available, and a judge of the commercial court who has experience of shipping matters, along with a number of other colleagues, had taken on the burden of being prepared to hear collision actions. And in those circumstances, it seems to me that the appropriate course is to provide a judge with some guidance. And indeed, in the trial, I accept that the guidance I gave the judge was 100% KIVELI's fault, or at least 80-20, but that was the guidance. KIVELI's position was, irrespective of what finding you make on the rules, it's 100% it's 100% AFINA I's fault. And so the judge had no help from KIVELI as to what was the situation, if it was a crossing situation. For reasons I will come to when I come to deal with apportionment, I will say that on a proper reading of this judgment, the judge did consider, if he was wrong on Rule 14, what would be the position if it was Rules 15 and 17 that apply. The underlying fault in the exercise you've just been taken through by Mr. Carruth is that it looks only at Rules 15 and 17. When one reads the judgment, all the faults that have just been discussed were before the judge. He approached the question of apportionment on a much more holistic basis, as he should have done, by looking at Rule 2 and the other rules that are all applicable as well.
Rule 5.
Rule 5, Rule 8, Rule 7, and so on. And that, in a sense, comes to one of the points that I was going to make to you about what is not challenged, which is the judge's conclusion that the immediate cause of this collision was KIVELI's last-minute turn to port at C-1, and secondly, that the root cause of this collision was the failing of the master and the officer of the watch on board KIVELI. And he sets out his reasons at paragraph 19 of the judgment to start with, and I'll come back to all of that. And I make these points because I accept that the principal issue before this court on this appeal is an important point of principle that's intended to provide guidance to the wider maritime community on the application of Rules 14 and 15. But ultimately, the question is, should one disturb the judge's findings in the judgment as to the respective fault of these vessels? And as to that, we say no.
Whatever the outcome of the Rule 14 debate.
Whatever the outcome of the Rule 14 debate, my lord, yes. That is our position. And we say that for a number of reasons, which I will develop, but not least because the judge in this case did a very thorough job, not only in analysing the regulations, but also in that way that first instances judges do and are encouraged to do, in considering all the variables that were potentially before him that might play into which vessel was in fault and why. I make two sort of overarching points as well. The first is this. My learned friend's case on the application of Rule 14 becomes ever more complicated as I listened to it at first instance and as I listened to it today. And it will be part of my submission when we come to look at Rule 14, that yes, it's important in the context in which we find ourselves, namely apportionment of liability for a collision which shouldn't have happened. But its far greater importance is in providing practical advice to mariners who may or may not find themselves on the bridge of a very well equipped vessel with all the navigational aids in good visibility, or may find themselves on a substantially smaller vessel in poor weather conditions, about trying to work out, when I look at that vessel ahead of me, or off to the side of me, or wherever it is, what is the rule that governs how we should behave? And my submission is that the judge's interpretation of Rule 14A provides a simple formula that allows for a competent mariner to apply those rules in a straightforward manner, with the ultimate aim that collisions should be avoided. What my learned friend wants to now encourage you to do is to adopt a definition which is not apparent on the face of the rules, which requires a knowledge of not just possibly English Admiralty law, but Admiralty law across several jurisdictions, and an in-depth knowledge of the travaux, which by themselves are not easy to bring together anyway. Because he wants now not only to say it's all about the sidelights, he wants also to say it's all about the 6-degree arc around the bow of each vessel. And in order to know whether you're in a head-on situation, you need to know whether you and the other vessel are in the 6-degree arc. That's not what the rules say. You haven't been shown any authority to the effect that that is what the rule requires. You haven't been shown any commentary, certainly any commentary of weight, that suggests that that is the way the rules should be read. And I will take you to some commentary, particularly Farwell, that says that actually, no, that's not right. When you're looking at what is a head or nearly a head, the question is what is the relative bearing, not the reciprocal course, but the relative bearing within 5 to 6 degrees. What he also, so that's my primary point. Sorry, that's my first point about construction and about the complexity of his case. The second point I want to make about this is that this case is a little bit like the Apollo and the Sydney, in that the vessel that is primarily to blame, in this case KIVELI, in the Apollo is basically rolling the dice to see if they can find a way through the rules that avoids their responsibility for the collision, when that is not in fact what the mariners, the officers of watch on the vessel were actually thinking when they were navigating. And that is particularly stark in the present case, because KIVELI's case that the vessels were in a crossing situation at C-22 was never the view of KIVELI's officer of the watch. He never navigated in the expectation that he was in a crossing situation. He accepted that both in relation to the Cape Natalie, and just to remind you, the Cape Natalie was the vessel that was in front of AFINA I, which on his own evidence was in a head-on situation with KIVELI because he could see both masthead lights in line and the red and green side lights. So whoever's interpretation of Rule 14 you accept, it applied. And also in relation to AFINA I, he intended to pass at a distance which created a risk of collision, passing starboard to starboard at close quarters. And that's paragraphs 31, subparagraphs 5 to 7, and paragraph 87 of the judgment. And you find those in the core bundle at tab 8, pages 167 and page 108 and 178. So he always intended to create a head-on situation, but one where, in complete breach of the rules, he was setting the vessels up to pass green to green rather than red to red.
Did he give evidence as to whether he thought, you said Cape Natalie was straightforward, but did he say that he thought that the AFINA was in a head-on situation?
He didn't say that in relation to AFINA I, my lord, no. He said it in relation to Cape Natalie. But the finding of the judge, and I don't have the paragraph to mind, but I can find it, is that and it plays in to the judge's overall assessment of the situation, is that had KIVELI, had the officer of the watch reacted properly in relation to KIVELI, in other words, had he stern to starboard to avoid a head-on situation with KIVELI, with Cape Natalie, then the situation that subsequently developed with AFINA I would have been avoided. My lord, I'm conscious I'm starting to head into the detail of the case, and I don't want to do that. But as you've had a day listening to why it's all my client's fault, I just want to reset the scene a little bit. What you will be happy to hear is that, I hope, is that in terms of a roadmap for where I intend to go,
logical equivalent to a roadmap.
I could indeed call it my chart, my lord. Probably now my electronic chart, since you have to get paper ones specially printed, but on my ECDIS display for today. And within my target cone or zone. What I wanted to do was start by just looking at a little bit at the purpose and structure and language of Rule 14. And I will say that when you look at the structure and language and look at the natural and ordinary meaning of the words used, the judge is right. Then I want to turn and look at the other materials and broadly follow a similar line to Mr. Smith. Namely, look at the Eversmart, the Apollo, and the Lock of Vivek. Then I will look briefly at the foreign cases and just pick up what we say about Navigator Aries and the Veracruz. Very briefly look at Rule 18 just to show you the differences. And then look at the Travaux. And look at what you can take away from the Travaux. And perhaps more importantly, what you can't take away from the Travaux. And then very briefly, look at the commentaries. I will look in a little bit of detail at the guidance of the nautical assessor, not to affect the questions of construction, because I entirely accept that matters of construction are a matter for the court, as indeed did the trial judge. But my learned friend's submissions strayed not away from questions of pure construction into how the judge then applied Rule 14, taking into account the advice from the nautical assessor. And I will say that he was right to do so. I will also say, and I'll either pick it up at that point or when I come to deal with apportionment, that there has been no challenge before this court raised in the grounds of appeal, or indeed in the skeleton argument applying for permission, to the judge's reliance on the findings of the nautical assessor. And therefore, that advice cannot be challenged before you. And that obviously then plays into the questions of what questions your lordships might want to ask the assessors and whether in fact you should. And then I'll deal very briefly, hopefully at that stage, with was the judge right to find that it was a head-on situation? And try and deal with that very briefly by reference to each of the grounds of appeal set out in the grounds of appeal, so that you have our answers effectively to each of the stated grounds. Then ground 2, I'll look at the language and structure of the collision regulations and the case law. We say that it's inherently counterintuitive to say that if vessels are navigating in accordance with Rule 14, because the risk of collision exists, to suggest that at some point, while the risk of collision exists, they should cease navigating in accordance with Rule 14 and navigate, well, I'm not entirely sure what they're supposed to have navigated, which rule they're supposed to have navigated to, given the way the case is now put under ground 2. I do accept that if you're against me on ground 1, then ground 3 succeeds. And therefore I'm not proposing to say a great deal, if indeed anything, about ground 3. And then apportionment. I do say it's not open to KIVELI to challenge the judge's findings on apportionment, even if they're right on grounds 1 or 2. They didn't apply for permission, they weren't given permission, and I'll develop that point. That then leads into the separate question, if I'm wrong about that, should you interfere in any way, in any event, with the apportionment of the trial judge, and we will say, for reasons which I will develop, no. If you are nevertheless persuaded that apportionment should be reopened, then we would say you do have the option of remitting to the trial judge, and in circumstances where he heard the witness, where he had the detailed advice of Commodore Dorey, and where it does appear that you're now being asked to look behind the judge's findings of fact, if apportionment is to be reopened, then it is more sensible for him to do that, not least for the reason you give, my Lord, Lord Justice Coulson, that namely that if there were to be an appeal from that, it shouldn't be straight to the Supreme Court. And then finally, I'll deal briefly, I hope briefly, with the facts. So, my Lords, that's my ECDIS display, my chart for today and tomorrow. I want to begin, if I may, by looking at the object and the purpose of the rules. And just remind you of what the principles that the judge applied, which are it's common ground with the right principles to apply. Which are set out at paragraph 83 of the judgment in the core bundle, tab 8, page 177. I will apologise in advance if I forget to give you tab numbers now and again.
So 83 of the judgment, yeah.
Paragraph 83, my Lord.
Yeah.
And just remind you, in particular of subparagraphs 3 to 5, the object and purpose of the collision regulations is to promote safe navigation and specifically the prevention of collisions at sea. The international character of the collision regulations and the safety of navigation means that they must be capable of being applied, that they must be capable of being understood and applied by mariners of all nationalities, of all types, professional and amateur, in a wide range of vessels and worldwide waters. They should accordingly be interpreted in a practical manner so as to provide clear and readily ascertainable navigational rules capable of application by all mariners. They are meant to provide international rules. The trial judge then goes on to refer to a passage from the decision in the Malaysia 2, which again I commend to you, but I'm not planning to read out now unless it's of help. And we say the purpose of Rule 14 is straightforward. It is to minimise the risk of collisions by giving clearer guidance to mariners as to when a head-on situation exists and as to the required action in that situation. Now, the required action is, of course, for both vessels to turn to starboard, thereby avoiding starboard-to-starboard passages and the risk that that one vessel will turn to the other. And again, my lords, just staying in the judgment, that is picked up by the trial judge, both by reference to a passage from paragraphs 107 to 108, which are at tab 8, page 184 to 185. And you'll see, my lord, he has he sets out a passage from Cockcroft and Lemire at page 75, stressing the importance of avoiding power-driven vessels meeting on reciprocal courses or crossing at a fine angle should not alter course to port. And he then also cites, and I would again urge on this course, a passage from Farwell's Rules of the Nautical Road at page 305. And my lord, you have that in the authorities bundle, that passage, at tab 19, page 395. And while I'm very conscious of the level of reading that the court is being asked to do, if your lordships want some wider reading as to what is the background and the purposes of Rule 14 and as to its structure, the treatment at Farwell, in the extract that's in the authorities bundle, is probably the most wide-ranging. Now, my lords, that's what we say about Rule 14 taken on its own. Put it in its context. What was the intention of the amendments to the rule from the old Rule 18 to the new Rule 14? Now, what my learned friend wants to say is, well, look at the Travaux. Really, it was just to simplify the language, but no more. And we say, no, the judge was right to conclude that the purpose of Rule 14 was to widen and clarify the scope of its application to fulfill any lacuna that may have previously existed between the old end-on rule and the crossing rule. And again, my lord, that is a paragraph 119 of the judgment at page 188. And we say that in some ways, this case is the archetypal demonstration of why the wording of Rule 14 was changed. You had one vessel that could see the side light, both side lights and indeed both masthead lights of the other. One vessel that could see both masthead lights of the other and just one side light. Neither was in a crossing situation because they both had each other on the starboard side. So which one's the giveaway, which one's the head-on? But there can be no gap in the rules. The rule that applies in that circumstance is Rule 14, and that is what the intention behind the new rules or behind the amendments to the rules were. And my lord, can I take you to two documents to make that submission good? I will come back and deal with the Travaux in more detail later, but I do just want to now pick up a document you were taken to earlier, but it's the report of the Subcommittee on Safety of Navigation on the work of its 9th session. You have it in the authorities bundle at tab 15. At page 275. That's the first page. And
Yep.
This is a document from April 1970 when the drafting was at an early stage. And if one then goes through to page 278, and paragraph 10, one sees it says the subcommittee gave initial consideration to certain basic issues and instructed the group to develop at its next meeting provisional text on a number of items. It also established an order of priority for the work of the group. And then, my lords, if you look at subparagraph B, to review rules 17 to 24, 27, 23 and 29, with a view to providing improved text and permitting greater latitude for the right-of-way vessel to avoid close quarters situations and taking into account the need to clarify difficult terms. And we say that intention is the intention that underpins the wider terminology of the new Rule 14, or Rule 14 as eventually adopted in the International Convention, then carried into English law, when compared with Rule 18. And therefore the intention to introduce a test which allowed a vessel to assess the risk of collision by looking not just at the side lights, but also at the masthead lights, and which allowed the vessel to assess whether or not it was in a Rule 14 situation by reference to what she could see, rather than what both vessels could see. Part of that intention to give a greater latitude to right-of-way vessels to avoid close quarters situations.
Just pausing there, does the concept of the right-of-way vessel suggest that that language is more aimed at the crossing provisions and 1960 regulations, where one vessel got to hold its course and the other, i.e. it had right-of-way and the other had to give way? How does that concept of a right-of-way vessel transpose to Rule 18?
Or Rule 14 as it was to become, my lord, yes. Well, my lord, the language of right-of-way may not sit immediately easily with the language of Rule 4, with either the language of either Rule 18 or Rule 14. But it's very clear that the drafting subcommittee of the IMO intended not just to look at Rule 19, as I think it then was, but to all the rules concerning overtaking, head-on or crossing situations. And of course, in that context, while the use of the word right-of-way may not be immediately apposite to Rule 14, or indeed Rule 18, what is clear is that they were looking to ensure changes to the rules which allowed affected vessels to avoid close quarter situations. Now, Rule 18 or Rule 14, as it now is, may be unusual in the sense that it imposes an obligation on both vessels, but the context is clear in the context of this passage, in the context of this subparagraph. The intention is clear, namely that it's to give both vessels greater latitude to determine, other than by reference to the sidelines, whether or not they are in a head-on or a crossing situation.
Yep.
And we do therefore say just going back to the judgment for a moment, that what the judge says in paragraphs 187, 117, starting at page 187, sorry, that's tab 8 in the core bundle.
$117.
Yes. Through to 121 models, where the judge considers the differences between Rule 18 and Rule 14, identifies at paragraph 118 the restrictions that no longer apply in Rule 14, and explains that there is the effect of the new Rule 14 is to widen the circumstances where there will be a head-on situation. And highlights in paragraph 119 that essentially what the intention was to make Rules 14 and Rule 17C consistent with each other, such that under both rules, turns to porter to be avoided. Now, my lord, there's a reference there to a passage from Marsden at paragraph 7-320. Unfortunately, the publishers of the new edition of Marsden seem to have done away with paragraph numbers.
Perhaps it was the authors.
I'm reasonably certain it wasn't. But my lords, just to give you the reference in the new text, in the new edition, you find the relevant extract in bundle, in the authorities bundle at tab 21, page 414.
21, page
414. The slight difficulty now is that because the decision in first instance has found significant favour with the authors of Marsden, they have now cited from it at length, and some of the old text has gone. But in broad terms, the authors agree with Mr. Justice Bryan as to the intentions behind the new Rule 14 and the intention to widen the scope of its application.
So the passage really is the whole of the section dealing with Rule 14, starting on page 413.
My lord, yes, it is. Happily, it is a relatively short passage.
Yeah, but it's 413 through to halfway down. 415 for this purpose. That's what they say.
Yes.
And this is because this is what's the publication date, or is it a loose?
I believe it was August last year, my lord. But
Yes, 16th edition, 2025. So therefore, the 16th editions come out between the
Yes.
the judgment of first instance and it came out after the judgment of first instance.
Yes, my lord.
And the one before is the one that the judge cites.
So the law in the new edition is said to be stated as the authors understand it to be as at the 31st of May 2025.
And this judgment was only handed down on
In
the 9th
January.
of May.
The consequentials judgment.
I thought that the actual judgment after the sessions with the draft judgment sent to the parties 9th of May 2025, final judgment 16th of May.
Yes.
So one acknowledges the hard work of the authors. They were stating that to be the law as at the end of May.
Yes.
They had to have worked quite hard to shoehorn it all in.
They did indeed, my lord. I was just trying to look if there was a publication date separate from when.
Oh, that'll be months.
Yeah.
Down, knowing legal publishers, the authors will have produced it for them, and then by the time the publishers have done their illuminated lettering for each chapter, it's 6 months later. I bet you the publication date of that is October or later. Yeah.
Can we
All right.
get the pre-trial, pre-judgment version of Marsden? Do we have that, or
Well, we have the original authorities bundle from the trial.
but just that extract, if that's what the judge is referring to? It might
Well,
be
my
helpful.
lord, your lordship referred earlier to the extracts from Hurst referred to in the judgment in the original trial bundle. So, without wishing to put work on those behind me, maybe we can pull out from the original authorities bundle the extracts from Marsden and the extracts from.
So if the judge refers to something, it can sometimes be helpful just to be able to see what it.
Yes, I think we've caught now 2 of them, so that would be helpful, and it would be much more helpful to have those extracted rather than being provided with the authorities bundle that was before the judge.
My lord.
Is that a convenient moment?
It is. My lord, I was just going to ask one question, if I may, in relation to questions. Because my learned friend and I haven't discussed this with him, but we have discussed some questions and agreed wording. I have to say, in circumstances where there is a debate between us as to whether some or all of them are properly put to the assessors here today. But it did occur to me that if there is any matter which, following discussions between yourselves, you already have a feeling that a question or questions may be helpful, whether it would be appropriate for a message to come to our clerks so that we can think about any relevant drafting.
If that is the case, then you will get a message this evening. If you don't receive a message from us within an hour, you can assume that there isn't anything as things stand that would from us for you to sort of, as it were, build positively on. So if you don't hear from us within an hour, you can assume that in the first instance, we'll be interested in what the two of you say. I hope that's
That is very helpful.
right. Any other homework you want to?
Certainly no homework, my lord. The only thing I would do, even though it's late in the day, is add my thanks to those expressed by Mr. Smith this morning, both to the court, to the listing office, and indeed to Trinity House and the assessors, for enabling this appeal to come back.
Well,
So
I think I did indicate last week that if it was possible for Alan in the listing office to work a miracle, then my experience is he's very good at that. But the thanks from both of you will be passed on to him.
Thank you.
Thank you very much. We'll start again then at 10:30 tomorrow.
Court rise the table.
Yeah, can you?
I think it seems like we would generally have send an update at lunch. Yeah. Oh, okay. I'm staying up some. It's quite a lot of stuff actually.
I don't mind me raising that last point about questions, but I'd rather know.
That's brilliant.
But it's quite a bulk.
Yeah. There was no evidence of it and no findings of it.
Whereabouts
As against your
is
rather than as against.
Eastbourne. The transport for
I'll have to what I
think the people like need to take over the trains off. You know, they might go off an hour and a half. The trains are not reliable at all.
He made points about what the intentions were as against Cape Natalie, and he found made findings that we were prepared to pass at an inappropriately small distance. But you suggested that the findings that we